Dear student friends, today I wish to take up lecture on importance of legal studies and guidelines. In this lecture, I wish to cover the different categories of students that are seeking admission into legal studies and these prospects of future prospects of our legal studies and importance and greatness conferred on our legal profession, how it is conferred supreme status by Constitution of India and universally acknowledged as noble profession, and what are the various privileges and very privileges conferred on legal profession, independent privileges of independence of judiciary, privileges conferred on legal profession, review power, that is judicial activism. These aspects I will cover. Public interest litigation, inherent powers conferred on legal profession, and next, what are the what are the lectures I have. So there are some students are expressing doubt that my lectures have not yet been mostly not enlisted in playlists, which I cannot do, and I made a request to some student friends to arrange my lectures in playlist, and so that I wish to let you know what are the lectures I have covered so far and what subjects I have covered so far, and what are the lectures I am going to cover one by one in due course. This aspect, and how to follow the, what are the books you have to follow, how to follow the textbooks, how to prepare working notes, and so then important topics, important subjects, important topics to be which our students have to concentrate, not only for legal studies but also for legal profession, and languages, importance and significance of English language, Hindi language, and local language with reference to our legal studies, and also educate my students to make it possible to know shorthand, which will, how it will be helpful to you, and how to prepare working notes before examinations. These aspects I wish to cover in this particular lecture. This lecture will be very useful to you. Please watch this lecture. I am telling you in particular, this lecture will be very useful to you, not only in legal studies but also in legal profession tomorrow. Then you also inform this to your student friends, and to watch this lecture by sharing the same if necessary. As usual, before going to take up this lecture, let me take just half minute to pray God, pay homage to my reverend parents, late Rega Apparao, late Srimati Kantaratnam, my eldest brother, Professor Rega Jagan Mohan Rao, and my wife, Balivada Rega Tirumala Gauri, my academic associate, who helped me a lot in bringing out so many books that placed before you. And it's my duty to express my gratitude to my godfathers who are instrumental for my growth and development. I express my heartfelt thanks and gratitude to the authors of various articles published in internet. Finally, it is my primary duty and responsibility to express my deep sense of indebtedness to my student friends who are instrumental for what I am now. Now here, let us now take up what are the different category of students that seek admission into legal studies. In our legal studies, so the very brilliant students are there, below average students are there. Now, it is because of the reason that the student is average student and below average student, he need not worry if he works hard, he will be able to come up like anything, and how he has to work hard, I will enlighten such students. Now, admissions. Since while the admission into LLB is sought by different categories of students. The first category is some students have strong desire, deep inclination to do law. Though he is highly meritorious, he will be able to get medical seat, engineering seat in a national institute or MBA in national institute. But he would like to do engineering, law only. He wants to become lawyer. That is first category. The first category. Second category of students is some. There are some lawyers and judges. They want to make their children as their successors. Judge wants to make his son the lawyer tomorrow and judge day after tomorrow. Similarly, lawyer wants to make his son or daughter a lawyer tomorrow and judge tomorrow. There, though his son or daughter is meritorious, can will be able to get medical seat or engineering seat, they decide to put their children in legal law course only. That is second category. Third category is third category. There some students who made attempts, sincere and unstinted attempt for medical engineering and other courses, MBA, or having failed to get the seat. Such students join LLB as a last resort. That is one category. Next category students are their performance, their marks are not satisfactory. They won't be able to get any seat except a law seat. So that such student join this thing. So whatever, whether bright student joins or average student joins, the pattern of exam will be same. The preparation also has to be the same. So that is why the students, average students or below average students, need not worry, but they will be able to, when their brightness of their knowledge we visualize, we cannot say. There are so many average students and below average students having entered legal profession as a third class law graduate. He joins law. As a third class graduate, one may join law. He may come out with first class in LLB. He may become leading lawyer tomorrow. So that is why there is no any. But the thing is, you have to do LLB course wholeheartedly. If you do any work wholeheartedly, that work will be easier and brighter. If you do any work without any unwillingly, so you won't be able to flourish in that particular profession. So that is why, dear students, so here we have law students who possess more knowledge than law teachers also. When you check the internet, there are some students, they are writing articles of a wonderful standard, which some teachers, law teachers also won't be able to write that much standard of articles. So while preparing for any lecture, I take the help of such lectures, such articles published by the law students. While taking the help of articles published by the law student, I sincerely, honestly state that I acknowledge that particular law student as my teacher or guru, to take the help of his lecture, take the help of his article for bringing out these my lectures. So that what I mean to say is, never underestimate anybody, never underestimate anybody, never hesitate to learn anything. So we can learn from a father, can learn from son, and son can learn from father. Father should not hesitate that you are my, after all, my son, how can I learn from you, is what should not say. Similarly, a teacher can learn from student, and student can learn from a teacher. So this is my opinion. That is why, see, when you want to improve your knowledge, acquire more and more knowledge, you should not feel any guilty feeling. You should not have any ego. You must come down to the deepest point, so that you will be able to earn many things and many more things. Now, our students through their comments told me, sir, what will be the future prospects of LLB and what, how to prepare and all these things. Dear student friends, uh, here doing LLB is not a small thing. Doing medical and other prestigious courses is not a big thing. So here, even though is our India, the law of the land, Indian Constitution conferred supreme status to our law course. What is that supreme status conferred on legal profession? I will tell you in due course. But even this law course, legal profession, has been universally acknowledged as the noble profession. Our legal profession alone has been universally, globally acknowledged as noble profession, and our law course, Indian Constitution, not only Indian Constitution, the Constitution of any country confers supreme status on the legal profession, that is judiciary. What are these things? I will tell you in due course. So, if you sincerely take your prestigious law course very seriously, work hard so that you will be able to follow. Regarding prospectus and things you are asking, when you will be able to, when you are a law student today, tomorrow you may be lawyer, day after tomorrow you may be a judge. But getting through LLB exam, passing examination, LLB examination is not a great thing. One will be able to get through the exam because in post graduation level in LLB or MA or MCOM anything, the teachers normally do not fail the students. They pass the students with this. If the pass mark is 40% in some universities, 45% in some universities, 50% in some universities, but the LLB students will be given only second class degree. Though the percentage of marks 40% is pass mark, second class degree is there. When you apply for bank officers and all, they may ask if you second class 50%, second class in the sense 50% they will ask, and 55% they will ask. At that time, though you are given second class, your degree will not be useful. So that is why I sincerely suggest every student to get a degree of 55% or at least 50%. In Maharashtra, for civil judges junior examination, if the student is declared qualified in LLB exam with 55%, directly he can appear for judicial officer exam. In case if he doesn't have 55%, below 55, he will be required to wait for some 3 years. With 3 years standing, he will be required to do this. In some students, the judicial officer exam, entrance exam will be there. It will be in some objective type tests. Some 20 subjects will be prescribed. 20 subjects in the sense, some are subjects, some are acts. Some are subjects, some are acts. For example, in contracts, one contracts act is there, negotiable instrument act is included in contracts too, and partnership act is there, it is included in contracts too. Sale of goods act is there, it is included in contracts too. So like this, in transfer of property act is there, for that easement act is added. So see, maybe transfer of act, TP act is shown as one subject, one enactment, and easement act is shown as another. Code of civil procedure and limitation. So limitation is shown as separately, civil procedure code shown separately. Accordingly, around 20 acts or subjects will be there. So practically, there are 20 subjects, but technically they are 20, but practically there will be around 15 subjects like this. So we have number of in when I was studying LLB, that is the before 99 2000 academic year, the number of subjects prescribed for LLB curriculum, 18 subjects plus one practical training. And from the academic year 1919 to 2000, the number of subjects increased to 18 to 28. Today, recently, the number of subjects increased from 28 to 30. Today, 3 years LLB course, the student is required to prosecute 30 subjects. So 1 year, first year 10 subjects, second year 10 subject, third year 10 subject. If it is a semester system, first term 5 subjects, second term 5 subjects, and he is supposed to attend 5 periods in a class. It may be 1 hour, 55 minutes or 50 minutes. So the invariably the student is constrained to attend classes 5 periods, 5 periods. Normally, after third period, most of the students won't be able to remain in classroom. This is what how many classes are being conducted, how many hours are there in timetable, for how many classes students are able to attend. It depends on the circumstances and atmosphere of that particular institution. Somewhere students attend for five periods, and some place they are not. So whatever it may be, the students will have to attend. So you want to flourish as a good advocate or good judge, good advocate tomorrow, good judge day after tomorrow, you have to take minimum responsibility to attend classes regularly, and acquire the knowledge of the acquire knowledge of the subject acquire knowledge of the subject. When you take admission in any institution, you will be provided with some prospectus book. That prospectus book will contain syllabi and syllabi of each semester, first semester to last semester, and at the end of the syllabus, you will be advised to follow, refer the textbooks. So the textbooks that are mentioned in syllabus book, they are great book. They are the books of great authors. They are distinguished. They are written by distinguished scholars. The volume of the book may be minimum of 800 pages, 1000 pages, like that. So when you take that particular book, you have to prepare working notes from that, because for every exam, one exam to one exam, there will be only one day. Today one exam, one subject, tomorrow another exam. If you follow that particular book containing some 800 pages or 1000 pages, but you won't be able to refer the entire book. That is, so those books are not for particular examination purpose. They are for those books which are voluminous. They are not only for the examination present purpose, they will be useful throughout your academic career and professional career. They will be useful all times, because there in examination oriented books, the facts are mentioned, so very few cases will be there. The facts of the cases are mentioned in 4 lines or 5 lines. But if this textbooks, standard high standard textbook, for every there will be in a particular section or particular article, number of cases are reported in high courts and supreme courts. In every case, different issues take place. For every each and every issue, the how the trial court decided, how the high court decided in appeal, interpreted in appeal, how the supreme court interpreted in appeal. For that case, number of cases will be given. All these cases, there will be a lot of explanation, interpretation will be given. As a student, if you can read all these things to acquire knowledge, but you will not be able to write all these court observations contain for one case contains for one case there will be 20 lines, 30 lines, 50 lines, 1 2 pages, like this. So in when we write examination, you have to write a leading case, a latest case, and if any recent case is there with new interpretation, you have to write third case only. You have to sum up the particular case in 4 5 lines in small paragraph. In case some universities case comment is asked, you have to write case comment in a maximum of case facts of the case 4 5 lines, issues involved 1 paragraph, decision 1 paragraph, like that. 3 4 paragraphs, maximum 1 page you have to write. So if a case comment is specifically asked, if problem is given, for problem also you have to write like this. For writing answer, when once you write the answer, you have to write the meaning, its meaning backed by some Latin maxim or French Greek maxim or French maxim. its meaning, common meaning in one or three, 4 lines. Then its definition. There will be several definition. You have to choose the best definition, easily understandable definition. One definition you have to pick out, and it may be Salmon definition or Austin definition or Blackstone definition. One best definition you have to pick out, and if that concerned act is there, if that act definition there, you have to. So in the crime definition is there in section 40 IPC. Evidence definition there under section 3 Indian Evidence Act. Crime definition there in Criminal Procedure Code under section 2S, like this. So that definition as per that enactment you have to write. So 2-3 meanings and 2-3 definitions you write enough. But if there are 20 definitions, 30 definitions are there, if you write all these things, the time given to you will not be enough to justify all the answers. So it is to be borne in mind that when the student is required to answer 5 questions, because suppose the matter is simple pattern, they give 8 questions and ask you to write 5 questions. So 5 questions, writing all questions on excellently 3 questions, leaving 2 questions is not correct, because you have to adjust your time for all the 5 questions. You must answer all the 5 questions. Suppose last 4 questions over, 3 questions over, only half an hour is there, but instead of writing and allocating all entire residual half an hour to 4th question, you allocate 15 minutes to 4th question, 15 minutes to 5th question, so that you will be able to get more marks. If suppose if you write only 4th question, you get 8 marks. So if you distribute this time for 2 questions, you get 2 sevens or 2 6, 12 marks like that. Sometimes even 1 mark will be countable. It will decide your result. So that is why it is only the student career you will be able to learn the subject. When once after completing LLB, when you go to senior advocate and junior advocate, you will be required to attend so many jobs entrusted by your senior. If your senior is service matter, you concentrate on that service matter. Your senior is writs. You files generally leads to habeas corpus, mandamus, like that. You concentrate in that area. Labor law matters, labor law. Intellectual property and intellectual property. So like this, your area will be confined. You will go in that route only. You won't be able to get time. You cannot have more time to concentrate other subjects. So that is why when you are in civil side, you may become ignorant of criminal side, and when you are in you may be ignorant about arbitration. Like the labor laws, you may. So you as a lawyer, not only as a lawyer but also as a judge, you must have the minimum knowledge in almost all the subjects. To have minimum knowledge in almost all the subject, it is only the student career to learn the subject. When once you join LLB, legal profession, you won't be there. Suppose as when once you become a judge, if you refer any judgment, number of subjects will be crossed. When you go to All India Reporter and read one judgment, how many subjects you will come across, you can understand. So that is why as a lawyer and judge, you must have knowledge in almost all the subjects. Basically, out of these 30 subjects, some 18 to 20 subjects are there. You must have good entry in that particular subject. Otherwise, you won't be able to this thing. If you neglect in a student career and go to court, you will come across so many problems. When I speak about writs, don't you know about writ of habeas corpus? Don't you know about writ of mandamus? Don't you know about public interest litigation petition PIL? Don't you know about interpleader suit? Like this. Your colleagues will, when the colleagues question you, you feel lot of guilty. That is why you should not allow anybody to find you an accusing finger on the pretext that you are ignorant of some legal principles. You have to get yourself acquainted with each and every legal principle covering all the subjects. It is not a great achievement when compared to some other courses, medical and engineering. The efforts we take as a law student are comparatively less. What all we are required to do is we have to read more and more books. We are not required to go for any hard labor. We don't have any practical work except some moose court or something jail visit in final year. So I am not saying that it's ours. I am not underestimating, but when compared to certain courses, they are very hard. They have to stand in hot summer and do the practical work in some courses. But you need not have that difficulty. If we don't have that difficulty, we have to comfortably read more and more books, acquire more and more knowledge, so that when once you utilize your time during LLB course, you will be a good lawyer tomorrow and a great judge day after tomorrow. This is what for prospects after your LLB is over. After your LLB is over, if you it is better if you have some financial okay, financially no finance, you don't have any financial problem, you may put up practice in some high court area, high court in a city where high court is located. You can do practice in high court as a junior advocate. You join some competitive examination center. When once you join some competitive exam center, you will be forced, you will be constrained to learn more and more subjects. That is more important, because you can comfortably neglect your studies in LLB course, but you will not be allowed to neglect your course in competitive exam center. But naturally you will get that competitive spirit. Your friends, colleagues, they work very hard day and night. They learn many things. Suppose in quiz, some student wants to collect some 5 questions and will answer the others with the thing that I alone know these 5 questions answer, or my friends may not be able to answer this. He will put that question in that quiz. Everybody will give answer. So that will be the I physically witnessed in IAS coaching centers, Group 1 coaching center, the way in which they prepare. But in competitive exam center, it is better you witness the taste of and competitive spirit in competitive exam, the judicial officers exam, competitive center, or this thing. At least you will be, whether you get through the exam or not, whether you become a judge post or a civil service post is secondary. Primarily, you will get good knowledge when once you join some competitive examination coaching center. The level of teaching will be entirely different. So it will not be that much. So even in a law also, in the recent past, with the emergence of national law schools and some other prestigious schools, the legal education is the status and prestige of our legal education is being uplifted. They are taking much care to impart qualitative legal education, even though our legal education is neglected in some private colleges and university faculties, mainly because of paucity of faculty. The faculty is very limited in most of the institutions, government aided colleges and university faculties. That is why the number of teachers are not even 50%, but that is why the students are neglecting classes, and authorities also are not taking care, taking serious, because our students move to the students who attend classes is declining day by day. That is why they are not appointing the teacher. Secondly, there is a paucity of funds. The authorities are not providing the teachers, particularly in aided institutions and university faculties. In private institutions, they are providing enough number of teachers. Now coming to the this is a fact. So you do this after this thing. Suppose you are having some business in your native place. You have agriculture land. You have to take care of your family matter. Agriculture you have to take care, and you have to take care of your business. If that is the case, you have to do practice in local court. If the court is located in your town, you do this. Otherwise, in nearby town, you have some civil court, junior division or senior division court is there, you may do practice that like this. You need not go to high court because you are having the responsibility of business or agriculture like that. But as per professional ethics, one should not take up any trade or business while doing while prosecuting legal profession. But is a technical it is there, but you will not but you have to look after that unofficially, but you are not officially you are not entered as some businessman or something. But in spite of that, practically so many advocates are having if they have some personal businesses at home or agriculture, they are looking after that. And it is not technically it is not shown. So that is why for such people who have responsibility at home with reference to family businesses or family agriculture, they may prefer to remain in local courts. Otherwise, who don't have that obligation, they may prefer go to city, put up practice in high court as junior. But you need not worry that as a junior you won't be able to handle the case. But senior represents the junior. The senior will ask the junior off and on to go and represent his on his behalf for taking adjournment or simple matters. Suppose as a junior, if you get a good case, big complicated, a very good case, big case, offering good remuneration, though you are not able, you won't be able to handle that case, you can give it to senior advocate. The senior advocate will deal it, and you also will get a share out of that fee from the client. That is there. So if you are competent enough to argue on your behalf, on argue on one, you can represent the matter on independently. If you won't be able to handle the case independently, you may refer that matter through some senior advocate. That is that opportunity is also there. So try to become good lawyer tomorrow and very good judge tomorrow. So, but as in whether as a judge or and lawyer, you must be a good listener. You must be a the primary thing you must require is good listener. Good listener means you must have patient hearing. So even the client don't tell all these conk and bold, tell everything in 1 minute. The clients, different kinds of clients are will come to you. If they tell everything, they have to tell their problem in detail. You should hear that problem with a patient hearing. If you don't hear, when a client is telling one thing, you are thinking some other thing, you won't be able to do justice. You may lose the case also. Similarly, when tomorrow, day after tomorrow, even once you become judge, for you must have patient hearing what the plaintiff side advocate is telling, what the defendant side advocate is telling, that is what the public spotter is speaking, what the defense counsel is speaking, what the witnesses are telling, what are the expert witness, different person who appear before you and making statement. You have to record them you have to listen to them very carefully. Then only you will be able to give judgment. In certain high courts and Supreme Court, simultaneously the petitioner may be one, the respondents may be 5 to 10 and even above. For every respondent side, one advocate will represent, and petitioner side. Simultaneously, I physically witnessed in a High Court and Supreme Court, simultaneously 2 and above advocates speak to the judge, and it may be a single bench or division bench. The judge must be able to listen to them very carefully, and he will give he has to take decision on the spot in second whether to admit the case or give stay order or dismiss the petition. So one day the judge will be, High Court judge or Supreme Court judge will be able to dispose of so many petitions. So they spare seconds or 1 or 2 minutes. They won't give enough time to the advocate to speak whatever he wants. So you must be in a position to present your case in a very precise manner and to attract the attention of the judge. The talent also you must have as an advocate. This is most important. So as an advocate, you must be a good listener from client. As a judge, you must be a good listener from your you must be a good listener with patient hearing, so that you will be able to hear what different lawyers are telling, witnesses are telling, so that you will be able to give proper judgment. So these are the with reference to prospects and liabilities. So legal studies or legal profession, I told so many times, I gave a good number of lectures from. I covered almost all the syllabus in professional ethics. The greatness of legal profession. Legal profession is universally acknowledged as noble profession. The constitution of any country confers supreme position on legal profession. Legal profession is among all profession in this universe. Legal profession is noble profession. Any constitution of any country confers supreme status, because supreme in the sense constitution is supreme means any law, central law passed by parliament or state legislature must be according to constitution, but constitution is not according to any law. See, sovereign means some king or some state head. He is sovereign in the sense he is everybody in the country must be according to him, but he is not according to anybody. That is sovereign status. How sovereign status is conferred on state head, supreme status is conferred on text that designs the functionings and the governmental machinery of various organs. So in any government, any state, international level, state means country. In any state, India is a state, Pakistan is a state, America is a state in international law, public international law. So, if for any state, the supreme law of the land, constitution, the constitution prescribes various rules and regulations for functioning of executive, legislature and judiciary. So there are three organs: executive, legislative, judiciary are three main organs through which the entire governmental machinery is carried on. So among executive means council of ministers headed by chief minister and governor and state level. Council of ministers headed by prime minister and president of India and central level. That is executive. Whatever the cabinet, whatever decision taken by cabinet, it will come out as some GO or GR. It is binding on the respective concerned personnel. That is GO. That GO can be challenged if the GO causes any harm or violates any fundamental right or anything. Then that aggrieved party or group of party people can approach High Court or Supreme Court. Then this High Court or Supreme Court can set aside that GO passed by the state government headed by state cabinet headed by chief minister or union cabinet headed by prime minister. This is the power conferred on a maybe High Court judge or Supreme Court judge to set aside the action of the union, state union cabinet, state cabinet or union cabinet. Such supreme power is conferred on state. Similarly, if parliament, if state legislature passed a law, it can be challenged by anybody. The state government can, the High Court judge can declare that void and unconstitutional. Similarly, parliament passed any law, if it abridges or infringes any fundamental right or affects anything, it is challenged before Supreme Court. The Supreme Court judge can set it aside. So such a great power is conferred on judiciary. So the judiciary can question executive action and legislative actions not only at state level, provincial level, but also at the central level, union level. Such great power is given. So some privileges of parliament. Privileges of parliament mean, according to Article 105 of Indian Constitution, the members of parliament, Lok Sabha members and Rajya Sabha members, they are privileged. They are not subject to any whatever they speak within four walls, whatever they do within four walls is absolutely privileged. They should not. They are not subject to any civil and criminal cases. You know, dear friends, in Lok Sabha, Rajya Sabha, or state assembly or state council, the defeated, the opposite party, ruling party is there, opposite party is there, opposition party is there. The opposition party people naturally have grievance that they could not win the election, couldn't win the election of battle of election. So still they have a lot of grievance. Whatever good the ruling party does, they question it is bad. Even if really ruling party does something good, they say that it is bad. Suppose the budget is good, but they say budget is very bad. So if some policies introduced, the opposite party will say. In that process, the MLAs or MLCs may criticize even chief minister, central minister, or even prime minister. Within four walls, whatever they speak, they are not subject to any civil suit or a criminal proceeding. If they speak the same matter outside the four walls of assembly or council or Lok Sabha or Rajya Sabha, they are subject to civil and criminal cases. So that is why such privilege is conferred. So within the four walls of a state house or central house, any MLA or MP or MLC, a Rajya Sabha member, Lok Sabha member can speak anything. He is not subject to any civil or criminal proceeding, but he can speak even against central minister or even prime minister, but he must not speak anything about the conduct of the High Court judge or Supreme Court. See, so an MLA or MP in house can criticize CM, chief minister, prime minister, central minister, MPs, other MLAs, anybody, but he should not speak anything wrong about the conduct of High Court judge or Supreme Court judge. That is great privilege conferred. So the members of Lok Sabha, Rajya Sabha are conferred that privilege to speak anything, but High Court judge and Supreme Court judge, they should not speak. But when impeachment move on High Court judge or Supreme Court judge is moved, presented before Lok Sabha, then they can speak. Because the High Court judges, Supreme Court judges are appointed by the Supreme Court Collegium, Supreme Court team, a committee for five committee of five Supreme Court judges headed by Chief Justice. These committee will, as per the recommendation of Chief Justice of the respective High Court judges and Supreme Court judges, they will recommend the name. The collegium, when the collegium finalizes, then the matter will be sent to Union Law Ministry and it will be finalized. And when once it is finalized, the Union Law Ministry, it will be sent to the President of India for assent. Then High Court judges are appointed. High Court judges, Supreme Court judges are appointed by the Supreme Court Collegium, headed by the Prime Minister, headed by the President of India. They are appointed like that. They can be removed. Nobody, President alone cannot remove. Prime Minister of India cannot remove alone. The Chief Minister cannot remove alone. It is any High Court judge is to be removed or Supreme Court judge is to be removed. He should be removed by the impeachment move. The impeachment move should be presented before the Lok Sabha and Rajya Sabha. 2/3 majority should accept it. In India, nearly 28 times impeachment moves on High Court judges and Supreme Court judges were made, but nobody was impeached so far. One Calcutta High Court judge, a lady, impeachment move was made. Before it came for discussion, she resigned her job. So these are the various issues relating to this is one of the important. This is that how the Indian our judiciary has been conferred review power. Proposed Union Cabinet headed by Prime Minister recommends national emergency or state emergency. It is national emergency is proclaimed or state emergency or president rule is proclaimed. The affected state can approach the local high court. After S.R. Bommai case, it was the Supreme Court made it clear that if any national emergency or state emergency, it is mollified and it is proclaimed for political gain or something, something, it can be declared unconstitutional. The High Court or Supreme Court, it is challenged with High Court or Supreme Court, and they can the judiciary has power to discontinue the lift this emergency, lift the operation of national emergency or state emergency. Such great powers are conferred on High Court judges and Supreme Court judges. This is one more great thing. And the next thing is review power. And here the Supreme Courts and High Courts are having writ jurisdiction power, and they can issue five kinds of writ of habeas corpus, mandamus, certiorari, prohibition, quo warranto, like that. The aggrieved party can approach, they can give these writs. Public interest litigation periods. Suppose locus standi public interest litigation petition, I told you. Suppose the government GO or government law passed by government or GO passed by the government affected the interest of particular class of people. Suppose the doctors are affected, the doctors will have locus standi to approach the court. Suppose state government employees are affected, the state government employees will have locus standi. The person whose rights are affected alone can approach the court, it is locus standi. Suppose if the public if for the public purpose, public welfare, if anybody approaches the court, it is called public interest litigation petition. M.C. Mehta, a leading advocate in Supreme Court, filed so many a public interest litigation petition. One can file, an advocate can file, a lawyer student can file, a common man can file, a social organization can file a petition under section 133 CRPC in first class magistrate court, local first class magistrate court, and the public interest litigation petition can be filed in High Court under Article 226, and it can be filed under Article 32 Indian Constitution. M.C. Mehta, Supreme Court advocate, filed public interest litigation petition under Article 32 of Indian Constitution. And there is the Ganga pollution case is there, oleum gas leakage case is there. That is 1 year after this Bhopal gas tragedy, he filed Ganga pollution, oleum gas leak, and so many cases. Delhi vehicular pollution case, he filed case like that. That is so the public interest litigation petition. Sometimes without filing petition also, the court, the High Court judge or Supreme Court judge came to know about some atrocities, some irregularities, some injustice done to some downtrodden people through radio or TV or newspaper or anything. They came to know, then the High Court judge or Supreme Court can respond and correct that particular activity. Such powers are conferred. Next one is, this is what's called judicial activism. Inherent powers. But the High Court judges or Supreme Court judges, local judges, they are conferred supreme powers. They can give any judgment on their own without taking into account the law available before them. They can outweigh law, they can outweigh custom, they can outweigh traditional practice, and can give the judgment of their own. Such independent power is conferred on judges under section 148 to 153B according of Civil Procedure Code 1908, section 482 of Criminal Procedure Code. The judges of criminal courts, subordinate courts, can exercise that power. Under Article 227 and 226, High Court can exercise that power. Under Article 32 and 136, Supreme Court exercise their power. They can give discretionary power. The courts in Constitution conferred discretionary power on judiciary to take any decision of their choice whatsoever they find justice, for to ensure equal justice, social justice, and to uplift the rule of law. The judges are conferred these powers under CPC, CRPC, and Constitution to decide any case. But finally, there are so many subjects are there not defined. Some subjects are not, they remain not defined. Law of torts is not defined. Administrative law is not defined. Some concepts are not defined. Basic structure is not defined. basic structure is in Keswananda Bharati case, the concept of basic structure was coined. But what is basic structure? It was neither defined, and then it's not well defined. It's not any given any guidelines for this. And subsequently, the Supreme Court, depending upon the circumstances of case, has been coining new principles as a basic structure. In this basic structure issue, I explained in this amendment chapter, Constitution, and that is there. The concept of basic structure is getting elaborated in several cases through the interpretation of Supreme Court. What I told you. So what is basic structure is not there. So wherever there is no law, the Supreme Court, High Court judges or Supreme Court judges are correcting through their judicial activism. If law is not clear, when government is liable, when government is not liable, there is no any law. But still we are following 1861 sovereign non-sovereign dichotomy. So that is why sovereign non-sovereign dichotomy. Chief Justice Sinha in state of Rajasthan vs. Vidyavati made it very clear. Whereas we don't have any law, we are following the 1861 sovereign non-sovereign dichotomy coined by Chief Justice Peacock even today. Today, what if in the absence of any law, we have to take into consideration in traditional law only is what Kasturilal case Gajendra Gadkar said, and made a recommendation to the Law Commission to bring out a bill prescribing government liability. So when there are certain areas where law is not clear, there are certain areas where law is not there, that uncertainty and lawlessness is getting cleared with the intervention of High Courts and Supreme Court through the review power and judicial activism. Such a great powers have been conferred on judiciary. Judiciary is one of the three rollers. So we, the members of legal profession, come within the category is what we are very privileged to be in legal profession is what you should realize, and do your best to justify your legal profession by taking initiative in acquiring more and more knowledge by attending classes and reading abroad books. So this is with reference to importance of legal education. Next, books to what books you have to study. So when you are when you appear for examination, if you follow as per your standard, you take the book and prefer for the examination. So when you take the big book of great authors containing 500 pages, 1000 pages like this, you have to prepare notes. The books, big books are of high standard, written by great scholars. They are not designed for a particular examination, and they serve the purpose of law students, lawyers and judges, because in one particular section there will be number of cases. How many cases are reported practically? The number of cases are being reported every 3 months through All India Reporter. Supreme Court cases will be there, various High Courts cases will be there. If you see the quarterly of All India Reporter, the cases, some of the main points are being reported in the main textbooks. So, but one particular issue, there will be number of cases with footnote will be there. Suppose when as a student, if you write all the observations, what trial court said, what High Court said, so what Supreme Court said, how Supreme Court interpreted, what are the guidelines given by the Supreme Court. If you write all such things for each and every section, you won't be able to justify the 3 hours time to complete all your answers. But those things are for acquiring knowledge, not only as a student but also as a thing. When once you prepare the big textbooks, you have to collect the information. You have to prepare working notes, meaning the definition. There will be so many definitions. You have to choose the best definition, and if that enactment definition is there, you have to take that. For example, evidence meaning 1 or 2 lines, what Latin word it came, evidentia. Then meaning 1 or 3 lines. Next definition 4 lines. Any other definition is 1 or 2. Yes. then like that you have to write. So you should not write so many meaning, you should not write so many definition. Time will not be enough. Suppose one particular section, there will be innumerable number of cases, different situations take place for the crimes, murders, burnings, wife burning cases. So many things are there. Dying declaration, one person some will give, and dying declaration and first declaration, subsequent declaration, like this. So many things. So for the two dying declaration, not one, two, three times, four times. So these witnesses, so many dimensions are there. It may be CPC, CRPC, evidence, criminal law, particularly in murder cases. So all these things, if you read all that, you will be able to get very good knowledge. You can do your best as a lawyer. You can do your best as a judge day after tomorrow. For student thing, that much is not necessary. If that part of case comment is prescribed for study in any institution, prestigious institution like National Law School or any private institution of legal studies, then you have to follow. You have to present that. For that presenting for that particular only this thing. For example, when the teacher is supposed to take two, three subjects for it may be even prestigious institution of legal studies or small ordinary law college or university law department. But the student has to cover two, three subjects in take two, three classes in different section. He has to cover lot of volume. Suppose if he won't be able to teach in depth about one section. If he wants to go in section one section throughout week, he can speak about one section. That type volume is there. That depth in article. If anybody write article, he will spend 1 hour, one week and prepare article on that particular one section. So one may do PhD. He may do a lot of volume, 500 pages volume on that for particular one section. So the article purpose is different, PhD purpose is different, classroom purpose is different, lawyer purpose is different, judge purpose is different, like that. Some books are prescribed, designed, keeping in requirement of various things. So when once you, what area is required for you, in how you have best you have to prepare. When we were studying, our teachers were telling, for this point, this topic, you read that book. For this topic, you read that book. Like that they were telling. We had to go to morning library, evening. After referring all the books, we had to collect material of 5 to 6 pages, working whole day in the library. So that type of difficulty you don't have. Teachers like me have prepared that much ready-made material for you, collecting information, various sources. So you are free from such burden of going to library, collecting information from by referring various books. So this is what is called textbook. When once you want to choose any textbook, you go to textbook shop and you ask your seniors which book is good. You ask your teachers, and then they make note of the books suggested by your seniors and teachers. You go to bookshop. Don't go purchase the book immediately. You go there, stand there, read the book either in bookshop or read that particular book in library or from friends, and then whether that book is suitable to your standard, you finalize that and then you purchase it. Then it will be easy for you to prepare. So next, languages. Get Bar Council of the India. The legal education in India is regulated by the Bar Council of India. The Bar Council of India has been Bar Council of India is insisting consistently and unstintedly all the centers of legal education, that is law colleges and university faculties, national law schools, to impart legal education in English only. But however, most of the areas English is neglected. In so many states, the local language is only acknowledged. Local language is acknowledged. For example, if you watch YouTube, the number of videos are in Hindi only. If the videos are in Hindi, particular that with a short time, 10 minutes, 20 minutes, those videos are having lakhs and millions of views. Suppose lengthy videos like me in English do not have good videos. Of course, the student may like or may not like, cannot say. But here, a student want anything very short time. They don't want lengthy. But in some areas, in states like very few states, the people respect English very well. In most of the states, the people even class 1 officers who are fully qualified, highly qualified, having having occupied very good high positions, they never speak English. They speak always local language. In the process of speaking local language, some of them forget even English also. Some of them became reached to that position. They are not able to speak English. Like that also situation is there. However, they put their children in global schools, international schools, paying heavy fees. But this is. But anyway, dear friend, it is always better to write law examination in English only. English only. You have to require respect English. It is a globally recognized language. English is most English bar council is consistently telling. But however, in so many states, local language is introduced. In Bangalore, Karnataka, I saw long back. The question paper will be both in English and Karnataka. Whether a student is interested in English, he can answer the paper in English. Marathi, Marathi, either in English or in Kannada, he can answer the paper. In Andhra Maharashtra, the students can answer the paper either in Marathi or in English. Of course, in some states they never entertain local media. So that is why in most of the states local language is there. And I sincerely suggest you, dear friends, don't neglect any English. So when you prepare for the exam, for every subject you select first almost by heart at least 5 topics. When once you select the best topics 5, and out of that 2 3 questions will come certainly. If you write the first 2 questions excellently, the examiner will have very good impression, and will give marks liberally. For example, I tell you, you take the law of starts. For example, if you take law of starts, you prepare first strict liability. Next, you immediately prepare negligence. From strict liability, negligence, 99% question will be there. Each and every side heading and cases you almost by heart and write. And immediately after that, that voluntary non-fit injuria you prepare. Next, you remedies. So like that, I told the important questions in respective subject. You what subjects I told you, what topics I told you. You choose first 5 to 6 best topic and you prepare them. For contracts one, first you study, first you prepare quasi contract, then immediately you prepare a capacity of parties with particular reference to minor contract, and then immediately you go to remedies, and then you go to take a quantum of damages, agreement in restraint of trade. The most important 5 to 6 questions you prepare, and out of them 2 to 3 questions will come when once your presentation in the first class. So if when the question number 6 is very well known to you, you write question number 6 first only. Don't first question should be written first, second question should be written next. Whatever question you will be able to justify the best, you pick out that question and start answering, so that when once your performance in first 2 3 questions is excellent, and the examiner will have the same impression and will give you marks very liberally. So for each and every subject I am telling what are the important question topics, which topic you have to read first, which topic you have to read next. Like that also I told you. So that is why, dear student friend, I sincerely suggest you, as your well wisher, you concentrate, you try, you must be able to speak not only English but also Hindi. Hindi is equally important language, but with Hindi, most of the states spoken language is Hindi. Particularly in all capitals of India, Hindi, most of the people speak Hindi. Super. For instance, Pune, Bombay, there is Marathi local language, but most of the people speak Hindi only. If you go to Hyderabad, most of the people speak Hindi. So that is why Hindi is equally very important language. You must, in addition to your mother tongue, please try your best to learn Hindi and English fluently. Out of your qualification, you will be able to speak English no problem. At the same time, you speak learn Hindi very well. If your mother tongue is Hindi, you are very lucky. You don't have any problem. So whenever you go any state, you learn that particular local language. It may be Telugu or Tamil or Marathi or Malayalam, whatsoever may be. You concentrate the Gujarati or whatsoever. Every language is great. There is no, it is no any, there is no any difficulty to learn any language. If you have sincerity, if you want to learn any particular language sincerely, with deep rooted inclination, you will be able to speak any particular language within 6 months to 1 year. If you don't have that inclination, desire to learn that particular language, even if you work 6 years, you won't be able to learn the language, learn any language. So I would not be able to learn Hindi, speak Hindi fluently because of my academic schedule, book writing, lecture, office work and all. I could not concentrate. I lost a lot as I could not speak Hindi and Marathi very well fluently. I lost so many privileges. For example, if I would be able to deliver lectures in Hindi, the number of views will be in lakhs also. So that is what that privilege I lost. For the reason I lost Hindi. I cannot speak fluently. Many students are asking me through comment to give lecture in Hindi, but I expressed my inability to do so. Another friend, dear friend, for examination, you have to prepare working notes so that it will be easy, because for an exam to one another exam, there is only one time one book. Whatever you book, the book will be voluminous. You won't be able to refer it quickly within 1 day. Next, finally, I want to tell you one point. If at all your children, it is not too old for you to learn. You are not too old to learn, but try to learn typewriting and shorthand. They will be very useful in every walk of life. First, shorthand, if you can, suppose whether you can record in court hall, I don't know, but how leading lawyer is speaking, how judge is responding, that things you will be able to, if you can write in a thing, when a book, you can, that knowledge you can acquire. You will be able to practice the same in similar situation as a lawyer, and tomorrow, and a judge day after tomorrow. That is, if you are prohibited, no problem. You should not do it. Suppose you attend any seminars, national seminars, say state seminar, and any important meeting of intellectual giants, when the intellectual giants, great personalities, addressing on a particular subject in a state level seminar or national level seminar, if you know shorthand, if you can record all that in shorthand with the help of the speeches of various dignitaries, you will be able to write article, and that information will be very useful. In this context, I want to tell you one example. Previously I told, when I was doing LLB in evening college, one of my classmates was Sri Krishnamurthy, S.P. Krishnamurthy. He was a steno in Hindustan Shipyard. And there also I worked as a commercial apprentice. He was a colleague there. He was a classmate here. We used to come to college with one notebook, simple notebook. He was attending the classes very regularly. He used to record all the lectures delivered by the lecturer in shorthand. He doesn't have any book. He doesn't have any. He never purchased any book. He did not even get it typed. Though he has a typewriting, type machine and everything, but only shorthand I read. When in examination, he used to record the lectures of the teachers, concerned teacher. He was used to attend all the lecture and recording in shorthand. And with the shorthand book, that notebook, he used to read and prepare. He stood first in those days, and he stood college first rank that. So that is why shorthand is such a great thing. Suppose when you attend any national seminar, some high court judges, supreme court judges will give their speeches, valuable speeches, and if you can write in shorthand, it will be helpful. Typewriting also, I don't think you have to become typist, but my brother used to tell me, learn typewriting not for the reason to become typist, but you must learn typewriting up to examination. Because if you have no typewriting in computer, you must how you maintain the speed in you will be able to type very quickly if you have typewriting knowledge, and that practice will help you when you type letters and all in computer quickly. So, but cell phone it may not be possible, and only one letter, once a letter is touched, some word may come, but this is very short. Secondly, if you have typewriting knowledge, your computer speed you can maintain. You can very quickly you can type. Then second thing is in first paper is speed examination. Second paper is statements examination will be there. So there are so many, only written script is there with lot of jungling, diverting this sentence to that. That second paper looks like a route map. When you a taxi owner puts that route map to reach the destination, like that you have to put this word there, that word here, like this. When you type a letter or official letter, where you have to type from address, where you have to address, and subject, reference, respected sir or respected madam, dear sir, where, and where to begin, how to you use space, where to say thank you, where to say with regard, where to say put yours faithfully. See the order and presentation of the letter, you will be able to know you if you have typewriting test. But even today, so many well-educated officials, if any letter is dictated, they are putting so many mistakes. They don't know where to start that letter, where the from address and conclusion. All these things they do not know because they don't have the knowledge of typewriting. Thank you very much for your patient hearing, dear friend. You please follow these guidelines and inform your students to watch this lecture. Thank you. Thank you very much.